All right, hello and welcome. I'm Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. Thank you so much for being with me today. Today I want to discuss the Asylum EAD, the Asylum Employment Authorization Document regulations that went into effect on August 25th. All right, and the regulations, they're like 97 pages in a very small print inside the Federal Register, so they're kind of huge. But I want to give my summary of my understanding of the main changes that have gone into effect here, and I want to explain how they're affecting asylum applicants' eligibility to receive work authorization. So to do that, I'm going to share my screen and we'll get right to it. All right. So I'm going to do a little slideshow, play from the start. Cool. I'll move my talking head here. All right. And cool, away we go. Well, great. My talking head is gonna be in the way a little bit. Anyway, August 20, I'll just leave it there. It'll block off some of the title words, but that's okay. August 25th, 2020, EAD regulations. Basically, the main things that I want to discuss today are these 7, all right? First, there's a new, longer wait time. Second, you can only apply for an EAD if you enter with permission. Third, you can't get an EAD if you have a 1-year bar, all right? We'll talk about each of these in just a minute. 4, any quote-unquote unresolved applicant delays will stop the clock. We'll talk about what that means. Number 5, certain criminal convictions will no longer be EAD eligible. 6, there are changes to the validity and the length of employment authorization. And 7, I'll do a little bit of a conclusion, all right? And so we're gonna get into it. We'll start with number 1, which is the longer wait time. Remember previously, if you apply for asylum and if you don't have a decision within 180 days, at the 150-day mark, you could apply for work authorization. Now what these new regulations are saying is no longer at the 150 mark, you've got to wait a full year, a full 365 days before you can apply for a work permit based on a pending asylum application. And now I explain here that this only applies to cases if, when the law went into effect on the 25th of August, if you didn't have 150 days already. And so with the way that math works is, if you, basically this change applies only to cases filed after March 28th, all right, of 2020, because the March 28th date is when, by August 25th, it's the 150-day mark. And so I hope that makes sense. If you filed after March 28th of 2020, you're going to have to wait a full 365 days before you can submit your request for a work permit based on asylum. All right. The second change is you can only apply for an EAD after August 25th if you entered with permission. Okay. So what this says is you can only apply for an EAD if you entered with permission. If you entered EWI, entry without inspection, EWI, EWI, you will not be eligible for a asylum pending work permit. And I put also here, you will also not be eligible per these regulations if you were paroled into the US. So that's not really EWI, you're paroled in, but after a post a credible fear finding or a reasonable fear finding, okay? And so that's, it's even worse than just saying, hey, if you enter without permission, you can't get a work permit. It's also if you enter after you're paroled in, you entered with permission, but after a post credible fear or reasonable fear finding at the border, then you will not be allowed in, even though you've complied 100% with the legal process. All right. So we'll talk about the policy behind this in the conclusion, but that's that. Number 3, no work permit, no employment authorization document, EAD, if you have a 1-year bar. All right. So specifically, it says you cannot get an EAD if you have a 1-year bar until after the government, the adjudicator, USCIS, or in some instances, the immigration judge, has adjudicated the exception to your 1-year bar. And so if you file late, all right, even if you have a clear change in circumstances, which the law allows you to apply late, if there was some recent change that now all of a sudden you're afraid for your life to return to your country, if you're in that situation, you will not be eligible for a work permit until there's been an adjudicated and agreed upon exception to the 1-year filing deadline. The government says, yes, you meet one of the exceptions for changed circumstances or for extraordinary circumstances to the 1-year filing deadline. All right. Number four, any unresolved applicant delays will stop the clock. All right. And by the clock, we're talking about what used to be the 150-day clock to be able to apply for asylum. It's now a 365-day clock. So what this is saying is that any quote-unquote unresolved applicant delays will stop those 365 days from running. And this provision is fairly broad, and we're not sure exactly how the government is going to be using this provision against against our clients and against our applications. But what they say in the regulations is that it may include the following 3 things, all right? It may include 1, a request to amend or supplement a pending application for your pending asylum application. If that amendment or if that supplemental documents or whatever are quote unquote unresolved at the date of your EAD application, all right? So what that looks like is if you've submitted additional evidence in your case or a new piece of documents with your asylum application, then your EAD will be denied at that point if that new evidence hasn't been considered or if it's quote unquote unresolved. Second is if the applicant fails to appear to basically any part of the process. If you fail to appear for biometrics, if you fail to appear for your interview, if you fail to appear to that appointment after the interview where you're going to go and receive the decision, all right, then that failure to appear for any part of the process will count against you, and they'll call it an unresolved applicant delay. They'll stop the clock so that you won't be eligible to get a work permit, all right? And then number 3, submitting additional documentary evidence fewer than 14 calendar days before the asylum interview, all right, or a request for an extension to submit additional evidence will stop the clock for your work permit. All right, so just that. All right. Then the next one to consider is number 5, certain criminal convictions will not be EAD eligible. Based on my reading of the regulations, a person will not be eligible for an EAD if, 1, if you've been convicted of an aggravated felony. That's actually always been the case, all right? But there it is. 2, if you've been convicted of any felony in the United States or quote-unquote serious non-political crime outside the United States. Or 3, which is, in my opinion, the most broad and troubling, this number 3, if you've been convicted in the United States of certain public safety offenses, all right, involving domestic violence, assault, child abuse or neglect, possession or distribution of controlled substances, as defined by the Controlled Substances Act, including marijuana in any jurisdiction, even if marijuana is legal there. So be cautious, all right? Or driving or operating a motor vehicle under the influence of alcohol or drugs, regardless of how the offense is classified by state or local jurisdiction. All right? In my opinion, incredibly broad. If you've got a DUI, they're going to gonna deny your work authorization. All right. And so just be aware, be very cautious. If you have applied for asylum and if you want to be able to work lawfully in the US, have nothing to do with criminal convictions. And if, you know, the local authorities arrest you and charge you with a conviction, hire a criminal defense attorney who's good and who's willing to fight for you so that you can avoid a conviction. All right. Or have it be a conviction that has nothing to do with any of this stuff. Plead to something else, perhaps. All right. The next one to talk about is changes to the validity and length of your work permit authorization. These new regulations allow USCIS to limit the validity periods of EADs. All right, so we're gonna see how long your work authorization will be valid for. Well, it's not clear. All right, USCIS will be allowed to change the validity period. The second piece of these regulations is that work permission will automatically terminate following the asylum office denial. All right, even if it's going to go to immigration court, it'll terminate the EAD, and it'll terminate the EAD if you're already in immigration court 30 days after the immigration judge denial, unless the case is appealed to the BIA. And when you apply for your work permit, you're going to need to apply showing proof that you've appealed to the BIA. All right. The next thing here, it'll prohibit work authorization for individuals paroled in the United States following credible and reasonable fear interviews. I mentioned that with the prohibition for folks that enter without inspection. All right. And it'll prohibit work permit eligibility for individuals with pending federal court petitions for review. So what does this mean? If your case was denied by the immigration judge and now you've appealed to the Board of Immigration Appeals, and if the Board of Immigration Appeals denied the case, and now you're asking a federal court to petition, to review the BIA's denial, which you have the right to do, all right? And now those cases take years. If you're at the federal court level, you will no longer be allowed for a work permit while, say the circuit court in your area is reviewing your petition. Okay? All right, and so then my conclusion, basically all of these regulations are nasty, all right? They're bad news for people who are trying to fight for their right to request asylum in the United States. Asylum is something that is, created under international law. The idea is people who are afraid for their lives to return to their home country should have the right to request protection, all right? So that they don't get killed, tortured, subjected to violence, persecution in their home country. They should not be forced to be basically deported back to a country where their life or their freedom is in danger, all right? Based on these regulations, people that are fleeing and who are here in the US, they're not going to be able to get work authorization. And so what that means is asylum cases are difficult and they can be very expensive to litigate. And right now there are changes happening to US asylum law itself that makes these cases more and more complex. But now people that are in that situation will be less and less able to lawfully work, and therefore less and less able to afford the professional help, the professional support that these cases are requiring more and more. All right. So it's just going to put pressure on, people are still going to need to work to be able to support themselves, even if it's without a valid work authorization document. But basically, it's just forcing these people more into the shadows and working at kind of under the table as we speak, so to speak, which is not a healthy way to, to manage this situation of people who are in need of legal protection and are lawfully entitled to it. All right. The regulation changes penalize people from seeking a lawful benefit, even when the delays and backlogs are caused by the government. And right now, there are lots of backlogs that are in our asylum system. And, you know, people could say, hey, who's the cause of this? But, you know, it would be very faulty to say, hey, it's all on the applicants. No, the government is also a huge participant in creating and causing these delays, these backlogs. They very well could adjudicate asylum cases in a much more streamlined fashion, and they are not. All right, and so, you know, I think it's a little bit unfair to say, okay, now these applicants are going to need to be punished for seeking a lawful benefit that they're trying to obtain, and they're not going to be eligible for a work permit. But they're going to be punished for something that they didn't do. All right, they're expressing their rights under international and federal law here within the U.S. And really, the government is causing delays and pushing back against asylum applicants. And in my opinion, they're undermining the very, very important, very critical need for people to seek protection from deportation if their life or freedom is in danger. So my conclusion is, hey, we need to push to undo these regulations in the future. These regulations are not good, people. They're not. They're not good. And I don't like them. And I represent people who are outstanding members of society in their country. They did not want to come to the United States. They did not want to be fleeing for their lives from whatever violence, death threats, things like that they've encountered in their home country. You know, I've got clients that are coming into my office with bullets, all right, lodged in their bodies that doctors are unable to remove because it might paralyze them. All right, like I've got clients that are very much in danger if they go back and they're seeking lawful asylum. All right, it's a completely lawful process, and you know, and they desperately need to be able to afford the legal services, one, but really support themselves. All right, support their families, support their, you know, because they often had to flee their country at a moment's notice, given like some death threat. And, you know, now they're trying to put their lives back together, and our government is not recognizing the dire situation that they're in, and it's not really making that legal process one that you know, actually benefits. It doesn't even benefit U.S. society, because these people are valuable contributors to U.S. society. They could be paying taxes. They could be doing all of this stuff, contributing to the local economy, if only we would give them work authorization. So anyway, that's my conclusion. That's my analysis of these new regulations. Thank you very much for watching. If you have questions about any of this, all right, I'll stop sharing the screen here. If you have questions about any of this, you know, please let our office help you, or at least reach out. Feel free to contact our office. We'll put our phone number here below this video. We fight a lot of asylum cases. And another thing that I'll say is these regulations, like, you don't want to file for asylum in a half-assed way. All right. There's a lot of people out there that just, they'll prepare an application for asylum, but they won't include your full declaration. They won't include your full, you know, all the evidence related to your case right from the beginning. And you don't want that. If you're applying for asylum, do it in a professional, well done way from the beginning, because those application delays, those submitting amended information later on, it's going to mess up your ability to get a work permit. All right. So make sure your application is done as professional as possible from the beginning. That's another kind of takeaway to all of this. And so anyway, if you have questions, please feel free to reach out to my office. Thank you so much for watching this video. If it was useful, please subscribe to our channel, and please give a thumbs up to the video itself to let Mr. Google, Mr. YouTube know that this content was helpful. Thank you so much for being with me. I'm Otis Landerholm, Landerholm Immigration, A.P.C, where we fight for your American dream. Have a great rest of your day. Bye-bye.